Materia Tudor.
Thank you, Mr. Chair. I think we've had the clarification now from the Minister Nick Smith, where he has just now.
I apologise to the member. Point of order. I seek leave to table the email dated the 3rd of August from the Treasury Regulatory Pact in statement that makes that very clear statement that it is minor and doesn't change any rights.
Is there any objection to that?
Yes.
Mr. Chair.
Oh. Materia Tudor.
Thank you, Mr. Chair. So I just want to
order. We will start the whole speech again in a second. I am going to ask the member to reconsider. Members of the House have asked for that evidence to be tabled on repeated occasions, and I think it ill behoves the House to refuse to have something tabled which is not anywhere otherwise available and has been asked for by a number of members from at least two parties. I'm going to ask the member to reconsider his objection.
Speaking to that, Mr. Chair, the reason that I have objected is that on numerous occasions, exactly the same situation has occurred where New Zealand First has sought to table material which would be just as valuable to the House as a whole, and which has been requested by members of New Zealand First and sometimes by others. And for no reason at all, members on the other side of the House have objected.
The member has a right to object. There's no reasonableness test. Materia Tudor.
Thank you, Mr. Chair. So the Minister has, as I understand it, just confirmed to the House and the public that in his initial negotiations over Crown land that was to be used, that he in his wisdom decided ought to be used by developers for the purposes of building housing, he failed at that point to ensure the legal certainty of the use of that land. That was his failure. He could not I don't know what he said to those developers about the legal certainty of the use of that land or the status of that land in terms of the offer back. But what is clear from what he just said is that when he provided access to that land for building, signed the deals for the use of that land, watched as they spent hundreds of thousands of dollars developing that land, he could not give them any legal certainty about whether they could continue to use and on-sell it. And so what he is asking from us now is to clean up that mess he created in his failed negotiations. Now, I wonder then if the supposed legal risk is not actually coming from original owners of the offer pack provisions that he's taking away, but whether it's coming from the developers themselves. Because the developers themselves, as he's just confirmed, do not have legal certainty over the land on which they have now invested possibly hundreds of millions of dollars in building and infrastructure and resource consents, all of those things. So is that, Minister, the reason why Part 2 is included in this bill? Not because of a risk from the original owners who would otherwise be entitled to an offer-back provision under that land, but from the developers themselves that he has done deals with, knowing he could not give them legal certainty. Because that's what it sounds like to me, especially given this Minister will not go into any further detail about the nature of that legal risk. And the Cabinet Papers, it is the description of that, the detailed description of that legal risk that is redacted, and it's the only part of the Cabinet paper that is redacted, is where it goes in to describe, looks like it goes in to describe the legal risk in some detail. Now, I think that if he has a particular legal problem to deal with as a result of his failure to provide legal certainty to developers from the first instance, that may be a legitimate concern to bring to this House for urgency. It may well be. There may be a circumstance where he would talk to us about this in some detail so we understood the full story, because things do go wrong. You know, ministers make mistakes. This is the sort of thing that happens. And the provision that we would expect him to build in the law would be specific to that particular legal problem. Not as broad brush as this current provision is, which will remove for every possible original owner and their descendants their right to an offer back for any land that was given for state housing across the country. Doesn't matter whether it's in Auckland or for special housing areas. This provision is so broad, there could be hundreds, if not thousands, of original owners whose rights are being taken away. I mean, that's what he has created here, when he could have more clearly identified the legal risk, come and spoken to the opposition MPs about the nature of it, and we could have found a more effective and targeted way of dealing with that risk. Now, others have been here a long time too. We know there are times when you engage in a very specific, detailed conversation, highly confidential conversations with ministers about some of these kinds of legal and financial issues. I mean, all of us who have been here for a while have been involved in something like that to some extent at some point. And so there is an ability for ministers to work with opposition MPs to find credible and sensible ways through tricky legal problems, often tricky financial problems, that are created through a genuine mistake. And in those circumstances, as co-leader of the Green Party, I am more than happy to work with ministers to find an effective, logical, rational, careful means through those problems. But that is not what happened here. No. So what happened here was a bill was put forward through urgency. A very short briefing was provided, Mr Chair. Mr Chair. Chris, far forward.